this one has a.
Alrighty. All right, good afternoon, everyone. Court will resume with the May 17th, 2022 docket. And I have Mr. Hernandez and Ms. Singletary. Can you hear me? All right, very good. We have F 1144-22-4 in the interest of Antonella Hinojosa. All right, folks.
Go ahead, Mr. Hernandez.
Agustin Hernandez for Veronica Gonzalez. She is, she said she would be here. I don't see her.
Okay, there was somebody who's got an iPhone and they try to get in and they had no audio or anything like that. So we sent him back. Hopefully we bring him back, they can correct that. But it'd be nice if they put their name next to the iPhone or at least the cost number. So
Yes,
we can
sir.
immediately identify the parties and the attorneys, put them together, then we get you all here as a group. But when I have to cherry pick who's who and who's the iPhone and who's Moto, I can't find out. So the sooner everybody identifies themselves when they're checking in, that helps me and Ida bring everybody in at the same time. But here's
Yes.
iPhone, that could be her.
Yes,
If you
sir.
can recognize her, let me know, and then we'll see what we can do.
Yes, sir. It is my client, Miss Veronica Gonzalez.
She has no audio.
Yeah, she has no audio. And right now, no video. But we're set for status. What's the status about?
We were able to agree to mediated settlement agreement that takes care of a lot of all of the issues that we had, including agreeing to non-suit, the protective order without prejudice that we have filed in this honorable court recently.
Ms. Singletary.
Good afternoon, Judge Lopez Singletary here on behalf of my client Benjamin Hinojosa, Judge, and he was telling me that he was in the lobby in.
Benjamin Hinojosa?
Yes, Your Honor. There he is. Okay.
All right, I'm gonna bring him in. And I think she's iPhone.
But she has no audio.
But she has no audio. Maybe if we can put her on the phone or on speaker or something. Still no audio? Still no audio.
I don't know if Mr. Hernandez can call
Mr.
her.
Hernandez, if you can call her and put her on speaker, I think we can go that route.
Definitely. I could put her on speaker. That's not a problem. I can call her right now.
All right.
And Mr. Benjamin needs a video.
Right. We need to see Mr. Benjamin Hinojosa.
Yes, I'm messaging Your Honor. He works for La Jolla ISD, and I know that he has a really bad reception.
Okay.
Test.
Mr. Hinojosa, turn on your video, please.
Says it's on. Let's see.
Well, if you hear his voice and recognize him, I think that'll help a little bit there.
It says that. Can y'all see me?
No. We can see the other party, but we cannot hear her.
Your Honor, my client is on the speakerphone here in my office. Can you please say hello, Ms. Gonzalez?
Hello.
Got it. We got her connected. But we hear Mr. Hinojosa. Can you hear us, Mr. Hinojosa?
Yes, sir. I can hear you. Can you
All
hear
right.
me?
I think it's in the best possible way here. So what are we going to do here, attorneys? We're going to what? Do the divorce case?
No, Your Honor, this is a suit affecting parent-child relationship, Your Honor. This case was mediated by Mr. Garza, Your Honor. So at this time, I ask for the court to take judicial notice of all pleadings on file, Your Honor, including the mediated settlement agreement that was e-filed, Your Honor.
Court will take judicial notice of the entire file in F 1144-22-4 in the interest of Antonella Hinojosa, minor child.
No objection, Your Honor. No objection.
All right.
And then, Your Honor, I want to go ahead and read the terms and conditions into the record, Your Honor. And I think we only had one issue that was not resolved, Your Honor. I have sent a proposal in reference to the child support, Your Honor, so that if the court can allow us just to put some arguments, Judge, and I think if you make a ruling on this, we should be able to finalize it today, Judge, with this agreement and then just submit our orders.
Okay. All right. You gonna read the order? I mean, the
Yes,
agreement?
Your Honor, and then, do you want us to swear in Mr. Hinojosa? I know we can't see him, but
Okay,
question him on that.
okay. Can you hear me, Mr. Hinojosa?
Yes, Your Honor, I can.
You swear the testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
All right, thank you very much. You may proceed, ma'am.
And Mr. Hinojosa, go ahead and state your full name for the record, please.
Benjamin Paul Hinojosa Jr.
And Mr. Hinojosa, we attended mediation on April the 27th, 2022 with Mr. J.R. Garza. Do you recall that?
Yes, yes, we did.
And this case was settled and an agreement was submitted with everybody's signature. As part of that agreement, the mediation agreement listed that all parties shall be named joint managing consultant by the child, and that is Antonella Hinojosa, which is a daughter of you, and also Veronica Gonzalez. It listed that mom shall be appointed as the primary conservator with the right to designate the residence of the children with a geographical restriction to Hidalgo County. That dad shall pay child support pursuant to the Texas Family Code, and this regard provides mom's attorney with the documents necessary to determine the net resources and necessary to determine his legal child support obligation pursuant to the Texas Family Code. That this information was to be provided to mother's attorney no later than 10 days from the signing of this agreement. The child support shall begin May the 1st of 2022, and that this obligation shall continue thereafter until the child emancipates. The dad shall have medical, vision, and dental support insurance for the child beginning May the 1st of 2022. After the amount of child support is determined by the parties will discuss and agree as to an amount of retroactive child support that is due, if any. Dad shall have expanded standard visitation as per the Texas Family Code 153.317 as follows. Dad shall have possession of the child on the first, third, and fifth weekend of every month, beginning on Thursday. At the time the child school is regularly dismissed on Thursday and ending when the child school regularly resumes on Monday after the weekend. On the second and the third of every month, dad shall have possession of the child beginning at the time the child school is dismissed on Thursday and ending the following Friday when school is regularly resumed. Notwithstanding the fact that the child is not of age, this possession schedule will apply. Prior to the child being of school age, dad shall have possession of the child on the first, third, and fifth weekend possessions beginning on Thursdays 5:30 p.m. and then Monday mornings at 7 a.m. Pick up and drop off the child for this period of visitation at the child's current daycare. Holiday possession of the child as per the Texas Family Code. Summer possession of the child by dad shall be the first 2 weeks in July and the first 2 weeks in June. Dad shall designate which 2 weeks of the summer possession he will have in June, and mom shall designate which 2 weeks of the summer possession she will have in July. The parties shall give each other notice of the summer possession election to the other party no later than May 15th of every year. If no such notice is given by a party, then the other party shall make the election as to summer possession. Mom shall have the exclusive right to determine whether or not the child will have surgery that is considered as elective surgery as determined by the physician. Both parents must have surgery that is recommended by the physician. Parents shall not have guns in the home when they're in possession of the child unless such guns are safely locked up in a secure location. The parents agree that they will not have consumed alcohol or illegal drugs 24 hours prior to having possession of the child, nor during the time that they are in actual possession of the child. The parents shall communicate exclusively with each other through app close, which must be installed no later than 48 hours after the signing of this agreement. Mom agrees to dismiss the protective order currently pending in County Court Law Number 4, cause number P011922-4. The protective order shall be dismissed without prejudice. The parties agree to a mutual permanent injunction to include numbers 1 through 5 of the Texas Family Code Section 6.501A. And all discovery not related to determining child support shall be withdrawn by the parties. All discovery dealing with the information required to determine child support shall not be due 10 days from the signing of this agreement, and that these orders are effective immediately as of April the 27th, 2022. Now, Mr. Hinojosa, these are the terms and conditions that are part of the agreement that you signed. Is that correct?
Yes, they are.
And you're asking the court to approve this agreement. Is that correct?
Yes, I am.
Okay, and Your Honor, I have no questions on the mediated agreement. I pass the witness, Judge.
All right, thank you, ma'am. Mr. Hernandez, any questions?
Yes, sir, Your Honor. Good morning, Mr. Hinojosa.
Good morning.
There is a section of the mediated settlement agreement that I believe was not read into the record. It's almost exactly the same as another provision, so that's probably why it happened. It's number 10. And it states, prior to the children being of school age, dad shall have possession of the child on the second and fourth Thursday of every month, beginning on Thursday at 5:30 and ending on Friday morning at 7 a.m. Dad shall pick up and drop off child for this period of visitation at the current child's daycare. Is this correct?
Yes, yes, it is.
Okay. Your Honor, that is, those are the only questions I have for Mr. Hinojosa that have to do with proving up the mediated settlement agreement. If we are going to read other or ask for other provisions that are going to be included in the SAPSA order, then I have other questions for Mr. Hinojosa.
Okay,
I'm not too sure what you would like to do in this hearing, Your Honor, the status hearing, if you'd like for us, if Ms. Singletary wants to prove the case up in its entirety today for the SAPSA order to be signed at a later time.
Ms. Singletary?
Yes, Your Honor, we want to finalize it today, Judge. The only thing that is pending is the child support amount. As per the agreement, I was to provide the intended, Your Honor, all information. We provided to Mr. Hernandez a copy of his salary from La Jolla ISD, Your Honor. He's a salaried employee, so that was provided. And that's all that we're missing, Judge, the amount of child support.
Okay, so you have the amount, Mr. Hernandez?
Yes, we did. I have received a copy of Mr. Hinojosa's salary that he received last year and the additional stipends that he received for this past school year.
Okay, and as per those numbers, what do you come up with?
Well, the numbers that I come up with are different because I'm taking the stipends into consideration. And I have no evidence outside of what opposing counsel has said that Mr. Hinojosa will swear today that he's not going to coach next year, which would be why he would be receiving additional stipends. But the amount of child support that they come up with currently that Your Honor has to do with the regular school pay, 756.98, does agree with the Texas Family Code, and after his deductions are taken into consideration, Your Honor. But we have to talk about that. If there's a way, Your Honor, that you would be able to place a provision in the decree. I have an idea. I furnished it to opposing counsel yesterday very late, so I wouldn't, and I wouldn't think that I would have time to read it if I received it. So if I could read to you the provision, and then, because we could agree to it, but if we could have a provision in there that if he does decide to coach next year, the fall of 2022, or the spring for wrestling, because he coaches football and he's been doing that in the past. If we could agree to put some language in the order that says that if he does decide to change his mind and become a coach, that he will be giving those additional funds of 20% according to the Texas Family Code, and with deductions, that if we could put a provision in there that he will be doing that, then I don't see why we have a problem.
Your Honor, if I may respond, I did see a provision late last night, Your Honor, but Mr. Hernandez failed to mention that in that provision, they want to include that he paid for her attorney's fees coming back, Your Honor. We cannot agree to that. One, because it was not part of the mediated agreement, Your Honor, and second, because the law does provide if wages are to change going forward and exceeds the amount, Your Honor, there is a provision in the family code that she can absolutely come back and modify it, you know, at any time, Your Honor. So we're not in agreement to that provision because it doesn't comply with the law, Your Honor, because the law does not require that he pay for any attorney's fees coming back on a modification, Your Honor. So we're not in agreement to that provision.
Well, I think that if he is going to get additional income and the parties can look at that matter outside the courthouse and agree, that'll do it. But if somebody does have to come to court to prove that you owe me another $50 per month, and that was the case that you should have decided, outside the courtroom, then I think you should pay attorney's fees. But that's what I'm saying is that if he makes additional income and volunteers that information to his attorney, then his attorney tells Ms. Singletary, look, here's the additional income. Looks like it's going to be another $50 a month. And if you all could agree, great, nobody pays attorney's fees. But if it is $50, but you still say no way, and you do come to court, then we'd have to award attorney's fees. That's how I see it.
Yes, Your Honor. For the Texas Family Code, for Texas Family Code 156.401A2, it states that after 3 years. So that's the part that I'm trying to avoid. I don't want to have to wait 3 years to modify the child support order.
It's not correct, Your Honor. You don't have to wait 3 years. It's when there is a change, Your Honor.
Right, when there's a change, material change or
Circumstances, Your Honor.
Yeah.
That's incorrect.
correct. But I would suggest that is when that happens, if it happens, notify the attorney immediately, provide the information to the other attorney, come up with a number that it's supposed to be. Everybody signs on it, submit it, that'll do it. But if you do have to come to court to push that, then I can see where attorney's fees need to be paid. Okay?
So, Your Honor, if you could rule on my request, Your Honor, if you may rule in this, would be that we don't have to wait for 3 years in order to modify child support.
No,
as income does go.
no. Once there's a substantial change and whatnot, that's when you have to modify.
Okay, sir. So thank you very much. Would you be honoring the request that I made? That my client doesn't have to wait 3 years to file a modification?
What does the law say? You have to wait 3 years or you don't have to?
It says 156.401A2, a court may modify an order if after 3 years, the amount of monthly child support awarded differs by 20% or $100 from the amount in the current child support guidelines. It's just that he has a history of coaching for years. So him changing at this point, we want to agree to it, but at the same time, it's just that it doesn't agree with the history of his employment.
Mr. Rojosa wants to say something?
No, Your Honor. I can respond. Your Honor, what Mr. Hernandez is asking this court is to go outside of the immediate settlement agreement to add extra provisions that are not an agreement that we made, Your Honor. If that happens, then she can just come back and file the motion to modify. He wants this court to put that provision as part of this order, Your Honor. And I don't think the court can do that, Your Honor. That is a relief that's available to his client, to Mr. Hinojosa too. I mean, if he loses his job tomorrow, he can come back to the court and modify it, but we're not going to put in this immediate agreement, well, if Mr. Hinojosa loses his job, then she has to come back and pay attorney's fees. What Mr. Hinojosa is going to do, Your Honor, is add a provision so that my client becomes responsible for paying for her fees.
Okay.
If we can agree to, Your Honor, it's part of a relief that he can file as a modification, Judge, but it can't be included here, Your Honor.
All right. It won't be included. Okay.
And Your Honor, the other thing, Your Honor, is that on that, when we provided that information, the child is currently enrolled in Medicaid. So we're asking that she keep the child enrolled through there, Your Honor, and that Mr. Hinojosa reimburse the state. And we had included $57 medical insurance, Your Honor. And if she wants to keep it in the Medicaid, then I went ahead and asked HR for information on the medical support, Your Honor, and it'll be $465. So Mr. Hernandez, if we include him on include her in the medical insurance, then the child support is reduced to $675. So can your client keep the child insured through Medicaid?
Your Honor, I would have to look at the figures again.
They've been provided to you, Mr. Hernandez, on the child support calculator. If you look at it,
57
per month to reimburse Medicaid, and that will help your client, extensively. But if she wants him to enroll the child through his employer, then it'll be $465, and that brings down child support to $675.38 with a gross income of $4604.
You're saying that to cover the child by herself costs $465
It's
a month?
charging him, on the document that I sent to you. If you look,
Yes,
it says he gets paid bi-weekly, and if you look at the, medical, it's $215. On that document that I sent you, it says the pay rate is bi-weekly under calendar, so he gets paid bi-weekly. So if you have $215, that will be $465 a month. So we would have to add that and the child support calculator, and it reduces the child support.
yeah, but what you had given to me doesn't have the child included though.
It is, because it's part of his plan, part of his employee plan.
But, so here he put
Well,
the
I
child,
guess, Mr. Randall, the question is, the child right now has Medicaid. Can she keep the child under Medicaid? He reimbursed the state so that she can be able to get more child support for herself and the child.
I understand what you're saying. My client is not in agreement with that, but the $215 that he pays right now times 2 is $430, but this is how much he pays to cover himself. Isn't that correct?
No, he's covered for free, Mr. Hinojosa. When you called HR, you're covered for free. That's for the child, isn't it?
No, I believe that's just for me.
So then how much would it be for that? I thought you said that was for, how much is it for the child?
I don't have an answer. I would need to speak with HR regarding this. That was just the paperwork that was on my payroll, with myself included, but I would still need to figure out how much that would be.
Okay, then Your Honor, what we can do is just keep it like that, Your Honor. He provides a letter from HR to Mr. Hernandez, judge, and we'll include that for the medical judge, which is what the law requires, on whatever amount it is, but it's probably going to be more than $57 a month. Judge.
Right. Okay. All right.
We don't have evidence of that, Your Honor, at this time about the amount.
Okay, so we leave it out for right now. Yeah, include that other additional information from HR. And then we'll go from there.
Your Honor, there is another request that I have, and it has to do with the pickup and drop off of the child. In the order, in the mediated settlement agreement, it has number 9 and number 10, which talks about whenever the child is at daycare, that's where the pickup and drop off are going to be. As you know, my client had filed a protective order. I had filed a protective order on our behalf, and we dismissed it. We want everything to be as easy as possible. But at the same time, I think picking up and dropping off the children at each other's houses would be problematic. So we would like to have a neutral. I had spoke with Ms. Singletary about this, and I'm not sure if she's in agreement right now. Ms. Singletary?
Your Honor, I spoke to Ms. Hernandez, Your Honor. The only issue that comes up, Judge, is there's a mediated agreement, Judge. Everything is already outlined there. We can't change that. If other things arise, Your Honor, we need to finalize this order. He can file the motion to modify or something else, Your Honor, but we can't keep on going down every single number, Judge, and changing the terms and conditions. It does state there, pickup and drop-offs are to be at the daycare, Judge. So I'm just asking the court to keep, the mediated agreement as it is, Judge. We discussed it and we talked about not being at anybody's home. It's not saying that it's at anybody's home. It's saying.
Okay. Yeah, we'll go with them.
And Your Honor,
Mediated
yes, the mediated settlement agreement does state that, but it just says prior to the children being school age. What happens after she is older than school age? What if they have to pick up and drop off at each other's houses, considering the history?
Well,
we'd
When
like
they're
that
in school, Your Honor, it's pick up and drop off at school. It states that they're under number 7. When they are in school, it's going to be at when ending following Friday when school regularly resumes, Your Honor. So it provides for it to be at school.
Right. As there are
That's what I
some
heard earlier.
portions, there are some portions of the, excuse me, Your Honor. There are some portions of the order that I believe stated Sunday at 6 or Monday at 6. we're just looking out for the times that don't have anything to do with school
Or daycare.
or daycare.
Well, if
And
it's
I just
summer.
told Mr. Hernandez, Judge, that we need to keep that because it would be an issue. So if today we agree, Your Honor, that it's a specific place, what if mom moves to another city? What if, you know, things change? We can't, this right now, she's, prior to this, they were living in, was it Mission or McAllen?
McAllen.
McAllen. So it's McAllen, now she's in Westlaco. What's gonna happen if she moves tomorrow to a different city, Judge?
Mhm.
But she's not going to move outside of Hidalgo County according to the mediated settlement agreement.
Okay. So you already have, when the child is in daycare, it's one thing. When the child is in school, it's one thing. What about when the child is out of school, let's say summer? Where were the
Well,
pickup?
in the summer, Your Honor, both parents work, so the children are not home. They're going to have to be at a daycare, Your Honor, or at a camp because mom works full time and well, dad doesn't work, but mom works. So we're, you know, they're not going to be at home, Judge. They're going to be somewhere.
Okay. Well, then it'll be there. It'll be in daycare.
So if the child is not in daycare, Your Honor, could we state the police station where the child is attending daycare or attending school?
I guess you can say, I'm thinking here, if it's not at daycare, if it's not at the school, then it'll be, here's the third choice, so to speak. Given those two are not available, what's going to be the third one? You know, halfway between the residences, you know, what's going to be?
I suggest a police station where the daycare in the city where the daycare or the school district is located.
Well, either one, where she goes to school or the daycare.
So
Both are in Westlaco.
I'm sorry?
I believe that the daycare or the school district is going to be in Westlaco more than likely.
Mhm.
So just saying that the school, it's the place, the city that the daycare or
I
the
know.
school district is in, that police station, Your Honor.
Okay. Ms. Singletary?
I guess we could put the school, Your Honor, the city, just to be specific for enforcement purposes, because an order has to be clear to be enforced. So we could put the police department where the school is located and hoping that she doesn't move them in the summer to another school, Your Honor, but
Mhm.
being cautious, Judge, on changing the mediated agreement, Your Honor, to something for those reasons, but we'll defer to the court, Judge, whatever you want to do.
Well, yeah, I don't believe it's changing the mediated settlement agreement because it's talking about something other than daycare. And that's,
Well, and that's what we said earlier, other than daycare or other than school, there may be a third way to do it. And probably, and maybe you're right, the police station. And then which
Of
one?
the school. Of
The
the
sheriff's
school.
office? That's the
child
county.
is-
The
I
sheriff's
think you're
department.
mediating the case, Judge, and we do pay you mediation
That'll
fees,
be
Judge.
in
But
the
I think
county.
to make it easier, Judge, let's put the police station of the school that the child is enrolled.
There you go. That'll work then.
that's,
That'll work.
yes, that's fine with us.
Okay,
I'll be specific.
that's specific. That's right.
But
Okay, guys.
it would serve the police station of the school, like if the school has a police station or the city.
The city.
Okay,
Yeah. Okay.
okay.
Yes, Your Honor.
But Your Honor, just to clarify about the child support, we don't have an agreement, or do you have an agreement? Do you have a judgment as to what the child support is going to be, Your Honor?
Well, I haven't seen, I mean, I've only heard numbers and whatnot. I really haven't written anything down. So you guys look it over and give me your, I guess when you submit the decree and you leave that blank, give me your proposal and you give me your proposal and I'll choose one.
Yes, yes,
Okay.
Your Honor, can we leave it blank? We submit the proposal and the just.
Right. You give your explanation and he gives his explanation. Okay,
Perfect, Your Honor.
That's fine, Your Honor. Thank you.
all right.
That's all we
Thank
have, Your Honor. Can we be excused?
you. All may be excused. Have a great afternoon.
Thank you, Your Honor.
Thank you,
Thank
Judge.
you,
Thank
Your
you.
Honor.
Bye-bye. Okay, next.
Cross blank, number 1 and
1 and 2. All right, let me see here.
I don't know who was on the other side. I think Mr. Sunny Palacios withdrew.
All right, let's see. We got Mr. Cuddle.
Hello, Your Honor.
Yes, sir. Good afternoon. You're with Frostbank?
Yes, Your Honor.
All right. Did you replace John DeSantis or he's in the same firm?
We're in the same firm.
Oh, okay. Cuddle and Cuddle. Now on the other side, I have here on my docket sheet is Mr. Palacios.
He's gone, sir. You withdrew him last year sometime.
Oh,
I don't know what case Mr. Garza has. already.
withdrew. Okay. Do you know of any other attorney that joined this case?
No, Your Honor. That was kind of the hangup was this. We had a bunch of discovery that we sent to Sonny and didn't get anything back. And then he withdrew. So
Who this person
it's
is.
just been kind of sitting around waiting for a ruling. And
Okay.
I had to move to, I didn't realize that we were still sitting on that. So I had to reset the case for a hearing. And that's where we're at right now.
Okay, I have somebody here with 1956 and then 204. I want to know who that is. And then Mr. Aurelio Garza, an attorney, is also on the screen. I just want to make sure there's anybody in this case.
Sure. I'll wait, Your Honor.
Okay.
Because this is a
Mr.
default and a summary judgment hearing. So there's two sets of proceedings going on today.
So two proceeds. Okay. All right.
Yes, sir.
Whoever's on the phone ending in 204, identify yourself, please. Unmute and identify. Phone number ending in 204.
It's 1956 and then
Let's see.
stars and then 204.
Let's see.
Right.
Last numbers are 204.
Was Mr. Garza here for somebody else or you don't know? Mr. Aurelio Garza, can you hear me?
Please to unmute.
You need to unmute, sir.
I
Yes, sir.
can
Which
hear
is which is your case?
It's gonna be F06962224 with Tim Davis, Your Honor.
Okay. Tim Davis is in the waiting room. I just wanted to
Okay,
know what
okay,
case
okay.
this
We
was.
got you here. That will be Mr. Garza right there.
Okay, so I'm gonna put it back.
Okay. Okay, we took care of you, Mr. Garza. We'll call you right back.
To
We don't
identify.
know who that 204 is. Can you hear me, 204? Need to unmute.
Persona, si estás en el teléfono con los últimos números 204, tienes que identificarte a la corte, por favor.
Okay, take them out and see if they come back in again and see what happens here. Let's resume here with Mr. Cuddle. All right, court will resume here with the May 17, 2022 docket. One of them is default, it's a default hearing that is cause number CL 19-26-29D, Frost Bank versus Gladiator Contractor and Roofing LLC, Gabriel Manuel Lopez and Jr. and Rebecca Guerra. Mr. Cuddle, this default judgment is against which defendant? All of them or?
I believe that one is just against Ms. Guerra. Let me confirm. Yes, it's against Ms. Guerra.
Which one? Which Guerra?
Rebecca Guerra.
Rebecca Guerra. Only against Rebecca Guerra?
Yes, sir.
All right, then. Court will go ahead and take judicial notice of the entire file. Court will note that Rebecca Guerra is not in the waiting room. Therefore, Mr. Cuddle, you may proceed, sir.
All right. Well, if you have taken notice of your docket, then, Your Honor, I respectfully ask for entry of a default judgment against Ms. Guerra at this time. We filed back in 2020 against her, and if she's not answered since then, I don't have anything in my records showing that she's answered. We filed for default judgment on the same debt that we're seeking against Gladiator and Mr. Lopez today, which is a breach of account that was held with Frost Bank with an overdraft that resulted from the failure to balance it of the amount of $11,058.31. That's proven up by an affidavit that's included in the most for default judgments Exhibit A, submitted by a bank officer for Frost and sworn up before notary. And there's an attorney's fee affidavit also submitted in support by my colleague, Marcy Liggett, in support of an award of attorney's fees of a total of $2,765.86. And her affidavit describes the various tasks that our clerks and lawyers at the office performed in getting this case to this point. There's
All right.
also a certificate of last known address and her non-military status affidavits included in that motion. So everything's packeted together against Pesquera, as I understand it. So I believe she's ready for a default judgment.
All right, court will also additionally note that Rebecca Guerra is not in the courthouse either, because otherwise bailiff would have told me or one of my staff members. So not in the courthouse, not in the waiting room here. So therefore, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. All right, as against Rebecca Guerra only, right, sir?
Yes, Your Honor. Interlocutorily, I'm hearing you. I did file a final judgment against everybody for today, just so you know, and that's been accepted by the clerks as of a few minutes ago.
Okay, now, are we gonna need another one, a new one, an amended one? If it's gonna be just against Rebecca Guerra? It'll be an amended one, right? We might need an amended default judgment?
Well, what I did is I just called it a final judgment, and I said
Okay.
that you heard the motion for default and summary today. You found that she defaulted, and you entered a summary judgment against the other people today.
Oh, okay, we're gonna hear that next, right?
Yes, Your Honor.
Cost number CL 1926-2019, Frost Bank versus Gladiator Contractor and Roofing LLC, Gabriela Manuel Lopez and Rebecca Guerra. This is a motion for summary judgment. Yes, sir, you may proceed.
All right, same story here, Your Honor. I don't think there's a response that Sunny filed, and I don't think that anyone else filed a response after that. So,
okay,
we've put our proof together in the motion for summary judgment. I'd ask that you take notice of your docket to witness all that. We submitted those materials just a few days after the default materials back in 2020. So if it's almost a year and a half and no response, I don't think that there's any genuine dispute here about the facts. Very similar evidence. We have an Exhibit A, which is our affidavit from, we have the materials included in the summary judgment motion on the bank account, including the card to open the account and the bank statement. And then that is supported by Exhibit C, which is the affidavit in support of summary judgment, explaining the facts of the opening, the overdraft, and the balance due. And then I have as Exhibit D, my fee affidavit, which basically supported the same balance that we were seeking in fees that my colleague supported for some default judgment. I haven't seen a response, and so if there's no response trying to make a fact issue of the evidence, I believe the evidence shows competently everything that's required by Rule 166A, that there's a breach of contract that's been duly proven.
All right, court will hereby take judicial notice of the entire file. Court will hereby grant the motion for summary judgment, plaintiff's motion for summary judgment. Court will therefore now wait for a judgment for signature. All righty, sir, I think that'll do it. Anything?
Yes, I know Mr. Cotto already submitted a judgment, but I just think it's a lot cleaner if we get just a default on Rebecca Guerra
By
and
herself?
an MSJ judgment on the other.
On the other three?
Yes, because it's gonna, the clerks are just gonna.
The clerks are gonna go berserk because I don't think they're gonna get it. So how do we do it? You wanna clean it up?
Just one default for Rebecca Guerra and MSJ for the other three in one
Okay.
order.
Okay, then we're gonna have two final judgments, all right?
Yes.
Well, I could make it interlocutory. The way I wrote it originally was they were both interlocutory because I didn't know who was going to get heard first. And so since I bundled everything together, I made it all final for today. But I could make another one that's interlocutory and then one that finalizes the interlocutory.
You got it.
Yes.
That'll do it.
Right.
That'll work.
You got it. All right, thank you, sir. You may be excused. You have a great afternoon, okay, sir?
Thank you, Honor. And
Yes,
thank
sir.
you all.
Bye-bye.
Thank you very much.
Bye-bye.
Thank you. Okay, number 6, Mr. Timothy Davis and Aurelio Garza.
All right,
Maria Aguirre and Mario Aguirre.
All right, let me see here.
I have 2 Maria Aguirres. I need to know which is the one that is, because I need to.
Ooh, let me
Take
see
one
here. All right, let me see what's going on here. I got Mr. Garza and I had Mr. Davis. I see on the screen 2 Maria Aguirres and only 1 Mario Aguirre. So the score is 2-1.
We win.
There's Mario Aguirre. All right.
If Maria Aguirre can turn on her video. Which one is she on?
Yeah. There's
And
2.
then we're gonna get feedback if there's 2
Yes.
devices.
That's why we need only 1.
Maria Aguirre, turn on your video.
She needs to unmute as well.
Yeah.
Also, she needs to unmute.
Does she speak English, Tim?
Yes, she does.
Okay.
Maria Aguirre, you need to turn on your video.
Okay, I see you. There's,
I'm
is
gonna
that
remove
her
this
right
one.
there? Remove one of them out.
Okay.
Are we okay now? Can you hear me, Miss Aguirre?
Yes.
All right, there you are. Okay, Mr. Aguirre, can you hear me? There
Yes,
he
sir.
is. Okay. All right, we're here on, first of all, court will continue with the May 17th, 2022 docket. And we're here on F0696-22-4 in the matter of the marriage of Maria Aguirre and Mario Aguirre Jr. All right, and gentlemen, what do we have here?
Judge, we're set for temporary orders. I think we got everything worked out. And I guess I'll go ahead and just say what we got worked out was regarding the house, my client's going to have exclusive use and possession of the home. Mr. Aguirre is going to be allowed, we need to work out a time for him to come and remove the rest of his clothing or whatever personal effects. And I know his attorney also mentioned there was some of his family furniture there. I guess I'll let them speak to that. And he also wanted to get one of the televisions. And the only other thing, there's a Lincoln vehicle. I wasn't able to speak to my client about that because I'm actually here at the courthouse and she's at my office. And that's supposed to be for their daughter, but I'll see what the other side has to say about that exactly.
Yes, sir, Mr. Garza?
Yes, that's our understanding, Your Honor. As far as what Mr. Davis had said with regards to exclusive use of the family home, just to add, of course, she would be responsible for 100% of any expenses, including the mortgage, taxes, maintenance, so on and so forth. I think the end goal is going to be that either the house gets sold or Miss Aguirre keeps it and takes over payments.
Okay.
There are a couple of pieces of furniture, and Mr. Aguirre, correct me if I'm wrong, but I know we discussed it already. There's a dresser and a bed that belongs to your mom, and of course you want to take that. And boots and clothes belonging to yourself. You already have your F-250, so you want to be able to use that truck exclusively for yourself. There is a Harley, but we're not dealing with the Harley right now. There is a Lincoln Town Car that you want to get possession of so that your daughter, 16-year-old daughter, can use so she can take herself to school since she'll be living with you. He'll be the managing conservator. And we've discussed child support, and I believe we came to an agreement that there won't be any child support, at least temporarily, because we should be able to get this finalized within 45 days or so. And then a barbecue pit. I think they've got a couple of barbecue pits. Mr. Aguirre, family oriented, wants to continue that tradition. And if he can pick up one of those barbecue pits this weekend.
Oh man, at one time I had a problem with barbecue pits. There were two, one that the gentleman had welded and another one that was bought at Sears, one of those butane operated ones. And there was a big fight because both of them wanted the one that was welded. And I asked, why is that the case? And they said, because the chicken tastes better with the one that the gentleman welded. So all I did there was flip a coin, and I don't know who won, but it was a coin because it was either, his or hers. But they were fighting for the same barbecue pit, but there were two pits. Because I told the lady that's easier to operate. It's got buttons and whatnot, and all the bells and whistles. But she didn't want that. She wanted the one that the guy welded. So I hope you all agree on this one, and don't let me flip that coin again, okay?
That's the good point on this one, Your Honor, is that Mr. Aguirre is, it doesn't matter which one. I think there's one been sitting for 5-6 years. So, he's
Okay.
cool with taking that one.
Okay, so then that's the agreement, just reduce it in writing, make sure it's signed by the attorneys.
Just let me ask Miss Aguirre on the link and make sure she's okay with that because
With the
Miss
Lincoln?
Aguirre, yes.
Okay.
The Lincoln was a gift for my oldest daughter that when I sold my piece of land, I bought that car. It was gifted to her so she could go to school. She's had cars since she was 16. She's now 22. She's the one that has been maintaining that car. She's put a new motor in it. She's the one that's been doing all the repairs to that vehicle. That car was not, it was gifted to her. And that's not gonna be taken away from her because that's her car.
So it's her car, okay.
And that's
Your
the
Honor,
oldest
just-
daughter.
I think, and I'll advise Mr. Aguirre, and we haven't talked about, at least temporarily. I understand that that it's titled under his name, neither here nor there, Your Honor. Mr. Aguirre, hopefully you agree with me. We can at least put a temporary hold on this, since I think we can get this finalized within 45 days between your lawyer and Ms. Aguirre's lawyer. And push comes to shove, we'll go to mediation and get that sorted out. You okay with that, Mr. Aguirre?
We're good.
Yeah, so we won't worry about the
Okay.
link for now.
Yeah,
Okay,
if
sounds
if the
good.
par- if the more you folks agree on everything, I mean, you're gonna save more money because you don't have to mediate, you don't have to go to other, just get it done as soon as possible among yourselves, and you
Just
save
bought
more money.
another vehicle, so why does he want the Lincoln? He has a Mustang he just bought.
Okay, but right now, we're not gonna give the Lincoln to anybody or anyone. We're gonna just leave things as they are right now, okay? So you all agree on the temporary orders and submit them in writing for the court signature. If not, there'll be some mediation. It'll cost more money for everybody, okay?
Yes, sir, Judge. We'll get it done.
All right, good luck, everyone. Have a great afternoon. You stay safe. Bye-bye.
You too.
Thank you.
Remember the barbecue pit, okay?
Won't forget it, Your Honor.
Okay, all right, bye-bye.
Okay, on number 3,
Oh, number 3 here.
they called the office that they have an agreement to pass the hearing for today, no action.
Okay, let me call it here. Cost number CL 21-1427D. Teresa Sipes versus Elizabeth N. Berger. There's an agreement
Yes.
reached by the parties.
And then the last one, no show.
Okay, let me call another one here. Cost number P0151-21-4. Hermenegildo Martinez versus Claudia Martinez. No shows. Nobody showed up here in court or